Good morning, everybody. My name is Sarah Darling, and I'm the communications lead for the office. It's great to see everybody joining us this morning. We have 40 people in the room right now and more coming in all the time. Just a couple of housekeeping things before I turn things over to Jay Chalk, our ombudsperson, and Nathan Paul, our lead investigator and manager on this investigation. I just wanted to point out that we are using Zoom webinar today. That means that you can ask questions through the Q&A function. You'll see it just at the bottom of your screen there. You won't have the opportunity to ask questions live, but I will be moderating the questions and answering them as they come in. And at the end of our session, we'll have time for Q&As with Nathan and Jay. So I'll be posing some additional questions to them. If we don't get to your questions today, happy to just have them emailed to us directly. We'll have the information at the end of the session where you can send your questions and we'll be happy to answer them. You'll see that we do have closed captioning on automatically. If you want to turn that off, you'll see the closed captioning button just at the bottom of your Zoom screen. And without further ado, I would just like to introduce Ombudsperson Jay Chalk. Jay, over to you.
Great. Thank you, Sarah, and good morning, everybody. This webinar is being hosted from our office on Fort Street in Victoria, and I'd like to acknowledge with great respect that the Office of the Ombudsperson is located on the traditional and unceded territory of the Lekwungen-speaking people, the Esquimalt and Songhees First Nations. But of course, our work extends across the great many homelands of Indigenous people across British Columbia, and we humbly acknowledge their stewardship of those lands as well. And in doing so, in making this acknowledgement, I just want to reaffirm my personal commitment to reconciliation with Indigenous people. And we'd also just invite you to reflect as we start this webinar on the land that you're working and living on. And you'll see a link on the page that can provide you with a little bit of history, language, and culture of the Indigenous people in your area. And with that, I'm going to turn it over to Nathan.
Everyone, hopefully you can hear me and see me. I'm Nathan Paul. I am the manager of investigations for the social programs investigation team, part of the office. And it is my team that was leading the investigation that led to the report Misinformed. So Jay and I will be leading the discussion today for the report that, as you know, we just released on the 6th, which of course is Misinformed, a story about how the Ministry of Children and Family Development here in BC failed in its permanency planning obligations to Alexandra, a former youth in care. So I believe you should have a copy of the report that was part of the invitation you've received today. Just to pause here for a second, the Misinformed investigation and the report that ultimately was produced certainly important piece of work for our office to have achieved recently. And the report was released publicly, and we felt the need to do so for several reasons, which we'll get into more detail as we go. Firstly, I think the most important aspect of Misinformed is Alexandra herself. She came to our office with a really simple and strong message that she wanted to be heard. She wanted to experience what happened to her known. Unfortunately, her experience, both when she was a child and youth in care, and with the events that happened afterwards, which Misinformed is obviously about, share a lot of similarities, regrettably, with things that happen to a lot of children and youth across BC. That's certainly an important piece of this work as well, is to amplify not only Alexandra's voice, but the voice of others in similar situations. As we know, Alexandra was in the ministry's care because for a time in her growing up, she was unable to return home. And And so this left the ministry with the responsibility to make a number of planning decisions to look out for her best interests. And so what the report identifies is a series of mistakes that the ministry made as part of its permanency planning process that ultimately left her unable to access the post-majority entitlements for educational and health support that she had believed she would receive based on what the ministry had told her. And then, of course, the report itself focuses on the Ministry of Children and Family Development, and having refused 3 of the 5 recommendations that we called for in the report, we're concerned about the ministry's ongoing refusal to both compensate Alexandra and to give life to the other 2 recommendations that they rejected. And so our hope is that through the work that we've done and through this webinar, we can continue to urge the ministry to take the steps necessary to not only compensate Alexandra, but to improve oversight of its processes generally to ensure errors like this don't happen in the future, and to, of course, maintain public confidence in the child welfare system. I think that's over to Jay.
Great, thank you, Nathan. So just before we start, a little bit of background for those of you who may be less familiar with our office and how we serve people across the province. The Ombudsperson, the Office of the Ombudsperson has been around for a little over 40 years now, and we can receive and where appropriate investigate complaints about over 1,000 public bodies in British Columbia. That encompasses the broader provincial and local public sector, hospitals, health authorities, agency boards and commissions, K-12, education, as well as post-secondary education, and of course, provincial government ministries. As this slide highlights, our goal is to make sure that those public organizations follow the rules that apply to them, whether they be embedded in law or regulation or policy, but more globally to ensure that they treat people fairly. We do that really sort of through some big characteristics of our office. Number one, we're independent. Our office is one of 9 offices of the legislature, so our accountability is entirely to the Legislative Assembly, not to the executive branch of government. The Premier and Cabinet or just other public bodies we investigate, no different than the hundreds and hundreds of others. The purpose of that independence is to ensure the next bubble, the pink bubble, that is being impartial. Our job under the Ombudsperson Act is not to be on one side or another. It is to stand in between and be impartial and be guided by the evidence that we glean during our investigations. And why that's really important is that by not being an advocate for complainants or an apologist for public bodies, when we do find that government has treated somebody unfairly, it comes with additional heft, because governments know that it didn't start from a predisposition or a place of that was already on one side. It really was guided by the evidence that we found, and we have found that over the decades that has led to, in most cases, although as you'll see today, not all, a responsiveness from government when they see our arguments and see our recommendations. We're confidential. The Ombudsperson Act requires that we conduct our investigations in private. What that means is that it's confidential for the person who comes to us, but it's also it means that we do our work very low-key, in a low-key way behind the scenes, and that means we get a lot of candor from the public officials that we speak with. There aren't, television lights on. There isn't cross-examination of them, and so we get a lot of candor in our experience as we speak to those people. And we're free. It doesn't cost anything to bring a complaint to us, so we try to be accessible to everybody. In terms of the kind of workflow, people come to us, we receive their complaints. Sometimes somebody may be complaining about something that we can't help them with, say the Government of Canada, for example. But in those circumstances, we try to practice as much as we can the sort of no wrong door philosophy, and we try to have a good warm handoff to somebody who can help them. But sometimes, that's what we have to do. Other times, we may be encouraging the person to go back to the public body that they're unhappy with because they've had one bad interaction, but there might be a review or appeal process within that public body. We encourage people to use that when it's available. But we always say, if you're still unhappy after you go through that, please come back and then we can take another look. But where someone's done those things, then a matter goes to one of our investigators, and it's their job to conduct an investigation that can involve obtaining records. We have statutory powers to collect records, including records that aren't otherwise public or releasable. And then we assess whether or not that public body has treated the person fairly. And if we come to the conclusion that they have, and we do sometimes obviously come to that conclusion, then we're writing a report back to the public body and to the complainant explaining our investigation. But where we find that in our view that they have not treated the person fairly, then we are going back to the public body with our recommendations for individual or broader recommendations for change. And so it's really that recommendations for change role that can lead to improvement in public administration. And our belief is that the model really can change the way public bodies think. And so we actually think that even though some people may think recommendations don't sound so powerful, we think that in most cases it can. And where, as you'll see in this case, those recommendations are declined by a public body, then sometimes we'll make the matter public. And that's what we did in Alexandra's story. So just moving from, that sort of broader what we are and what we do, I want to talk a bit about this particular investigation that we did. And as Nathan did, I just want to acknowledge Alexandra's strength and her courage for coming to us and sharing with us her story. So Alexandra is a former youth in care. She came to our office in 2021 with a really simple, strong message. She wanted to be heard. And despite receiving a series of rejections from the Ministry of Children and Family Development, she was really unwavering in her desire to see justice. And interestingly and importantly, Alexandra wasn't just interested in her own story. She was also interested in ensuring that what had happened to her didn't happen to other people. So with her permission, we used her real given name throughout our report as a way to honor her experiences and her courage and her resiliency and give voice to her story. We've heard Alexandra and we remain committed to working to ensure that ultimately the ministry will hear her too. And to ensure not just she, but other youth who are similarly situated are treated fairly as well. So Nathan's going to talk a little bit more about her background, and then we'll talk about what happened to her with respect to what became sort of the pivotal part of this investigation.
Thanks, Jay. So, as we can see, Alexandra told us that from an early age, she suffered from significant physical and emotional abuse in her family home. And as a result, she had extensive involvement with the ministry throughout her childhood and teenage years. Over the course of her life, she was removed and returned to her parents 4 times. And then on the 5th removal, when Alexandra was 16, that was the point at which the ministry ultimately determined that it was no longer safe for her to return to her family home, that alternate arrangements were necessary. So when she was removed at 16, initially the ministry presented Alexandra with 3 options. Although there's technical aspects to each of these, ultimately they boil down to the choice that she could choose to go out on her own. She could choose to live with extended family, her maternal aunt in this case, or that she could choose to stay inside the foster system. Ultimately, Alexandra chose to go with her aunt, but at the time she made that decision, she did not fully understand what the consequences might be, and she did not know that there could be long-term implications of the placement decision to stay with her aunt as part of what became the ministry's subsequent permanency planning process. So that process, ministry's permanency planning process, occurred when Alexandra was 17. That was when the ministry really drove the plan to have Alexandra leave the ministry's care on a permanent basis. Again, although there's many technical features to this, ultimately the permanency plan that the ministry pursued involved making a court application to permanently transfer custody from itself to Alexandra's aunt. It's an important feature is that permanency process created a legal change in Alexandra's status, but did not change her day-to-day situation because she had already been living with her aunt at the time the permanency planning process was underway. So the order that the ministry pursued and obtained under the legislation in BC is colloquially known as the 54.01 order. And it was one of several options that the ministry had available to it when it engaged in this permanency planning process. As part of the permanency planning, what remained clear is that despite the challenges that Alexandra had faced throughout her life, she had a clear goal that she wanted to pursue post-secondary education after completing high school, and that both she and her aunt had discussions with the ministry about Alexandra's future. And her aunt had made it clear in writing to the ministry that Alexandra wished to pursue her education after she graduated from high school. And the aunt asked whether she would receive financial support from the ministry if she agreed to the ministry's permanency plan. As our report shows, Alexandra and her aunt were told by the ministry that she should qualify for those supports, and the ministry committed to following up with her to with them to confirm her eligibility for these supports as part of the planning process. Unfortunately, the information that Alexandra and her aunt received was incorrect, in as much as both provincial legislation and ministry policy had the effect of disentitling Alexandra to a range of benefits that she believed she was going to receive by virtue of the 54.01 order. So what occurred is that Alexandra and her aunt ultimately were misinformed about what would happen when the 54.01 order was granted, and did not appreciate the far-reaching consequence it would have on Alexandra's ability to get the education that she hoped to pursue in the future. The error in the information that the ministry provided was compounded when the ministry did not provide Alexandra and her aunt with independent legal advice that they were entitled to receive by law when, and that's part of the process, the ministry followed when applying to the court to get the 54.01 order. The ministry's second error, not providing legal advice, was further compounded when the ministry's court forms that they were required to complete as part of the application process failed to confirm that Alexandra and her aunt both understood the nature and the consequences of the consent they were being asked to give life to the 54.01 order, which of course raises important questions about the voluntariness of their consent. And to be clear, the ministry's obligation to ensure that they understood that the consequences of their order were, of course, required under the legislation and under the applicable court rule. When we view it as a whole, the information that Alexandra and her aunt received from the ministry that left them with the understanding that they should qualify for the post-secondary support funding that they had inquired about, and the fact that Alexandra and her aunt did not have the opportunity to get independent legal advice that might have clarified their understanding, left them without the information to understand the full consequences of the 54.01 order. And this is the foundation of the findings that we made that the ministry treated her and her aunt unfairly.
So as Alexandra told both our office and the ministry directly, you know, the challenges that she had experienced early in her life meant that she couldn't imagine herself even completing high school, let alone attending a post-secondary institution. But you know, she doggedly determined to try to make that happen. And after she turned 19, she started to try and chart a new you know, future for herself. And as part of this, she received years of therapy, which she sought out on her own without any assistance from the ministry, and started to imagine a different life than she'd experienced up to that point. And she saw that education was really a key for her to deliver this. But she didn't yet know the ramifications of the actions that the ministry had taken back when she was 17 would have the consequences that they did. And she really didn't appreciate that until she was accepted to a post-secondary institution when she was 23. And when she was accepted, she began making financial preparations as any student would to begin her studies. She sought to access the programs that she believed the ministry had promised her, and she applied for support under two ministry programs that many of you will be familiar with: AYA, Agreement with Young Adults, and the Youth Educational Assistance Fund, or YAFE. And these programs are two important ways that MCFD provides financial assistance for former youth in care. And it was only after completing the application process for those two programs and being rejected for both that Alexandra learned for the first time that she was not eligible for those post-majority supports that she believed that she'd been promised when she was 17, and when the ministry was about to seek the 54.01 order. And it was really at that point that she understood that the permanency plan that MCFD had developed actually excluded her from eligibility for the very programs that she understood because of the ministry, or the information provided from the ministry. And so, unwilling to accept that the ministry had broken what she views as their promise to her, Alexandra wrote to minister to plead her case. And when the minister rejected her appeal, Alexandra brought her complaint to our office.
So, based on the concerns that Alexandra brought to us and the materials that she provided to us to support her complaint, we understood that the ministry had determined Alexandra was ineligible for financial supports through both the AYA and the YAF program based on legislation and policy requirements tied to Alexandra's status, legal status, when she reached the age of 19. While we understood that according to both legislation and ministry policy, the ministry could only enter into an agreement for post-secondary services for a young adult who up to their 19th birthday was in a youth agreement, was in the continuing custody of the ministry, or was in the guardianship of the director of adoption, or the director under Section 51 of the Infants Act. Our investigation confirmed that it was the ministry's own plan that they developed and that they drove that served to make Alexandra ineligible for the same services that both she and her aunt had clearly indicated were necessary for her success in the future. As part of our investigation, we had concerns about the ministry's permanency planning process that they undertook on Alexandra's behalf. And overall, our investigation confirmed that the ministry failed to consider Alexandra's best interests as they were required to do under the law, and which included her potential future interest in obtaining financial supports to pursue her post-secondary education. As we noted, our investigation revealed that the fact the ministry misinformed Alexandra and her aunt about the financial consequences of the ministry's permanency plan and the 5401 order lay at the heart of Alexandra's concern. Alexandra, of course, was not told about her right to speak with a lawyer before purporting to give consent to the ministry's plan. Alexandra did not receive a referral to speak with a lawyer at the ministry's expense, as was both required by ministry policy. While the court ultimately granted the ministry's application to transfer custody of Alexandra from the ministry to her aunt on a permanent basis, as we've mentioned, our investigation confirmed that the ministry left important portions of the consent forms required by the rules of court blank, which parts of the form indicated that Alexandra understood the impact of the custody order that was being sought. And as Alexandra herself said eloquently in her letter to Minister Dean, had she known at age 17 that she would not get the financial help that she wanted and believed that she was going to get if she chose to live with her aunt, then she would have made a different choice. Simply put, our investigation confirmed that the ministry failed to meet its legislated and policy-based obligation to ensure that Alexandra understood what was happening to her, what the consequences of the 54.01 order would be, and it did not ensure that Alexandra's voice was heard during the planning process, which was an important feature because of the importance of the planning process to her future overall.
So because of what we learned during our investigation into the ministry's actions in Alexandra's case, I decided to make 5 recommendations, both individual and systemic, to address the fairness issues that we had uncovered. And so to address the individual impacts for Alexandra, we recommended that the ministry compensate her by paying to her an amount that would be equal to the post-majority entitlements that she could have received had the ministry not misinformed her and acted unfairly. The ministry unfortunately rejected that recommendation. To address the staff awareness limitations that contributed to the unfairness that she experienced, I recommended that the ministry develop and implement strategies to ensure that staff understand and appropriately inform youth and their families about the consequences of the different permanency planning options that exist, as well as to ensure that staff are aware of their responsibilities to provide a referral for independent legal advice in cases where the ministry is proposing a legal permanency plan for youth over the age of 12. The ministry accepted both of those recommendations. Because of our concern that other children may have been similarly affected by the same mistakes that were made when decisions were being made about Alexandra's future, I recommended that the ministry conduct an audit to determine how many other youth may have experienced similar problems to those that Alexandra faced. The recommendation that MCFD conduct an audit, in my view, is particularly important because Indigenous children may be disproportionately affected by the fairness issues we identified when considering Alexandra's experiences, because that was one of the policy rationales for Section 54.01 being enacted in the first place. In our report, we mention a 2017 report of the Representative for Children and Youth that found that between 2015 and 2018, 1,014 children were subject to 54.01 order. So obviously, that's the number of people, I would say, over those 3 years, for example, that potentially were impacted, but without an audit. We don't know if there were, in fact, others and similarly affected to Alexandra, and if so, how many. The ministry, unfortunately, has rejected this recommendation. And I also recommended that an additional layer of oversight to safeguard the financial interests of children and youth be put in place before the ministry can go to court. And that would be by involving the public guardian and trustee in all court applications where the ministry seeks to permanently transfer custody to another person. This recommendation would allow that the PGT to review those plans and provide advice to the court to inform the court's decision about whether or not the transfer of custody is truly in the child or youth's best interest. This is a role the PGT has under many other British Columbia statutes when courts are considering making decisions that can impact the financial interests of a child. And so it's not an extension, or it is an extension, but not certainly an unprecedented extension to the PGT's role, and certainly consistent with other circumstances in which they're involved. But unfortunately, the ministry rejected that recommendation as well. So, one of the reasons that the ministry has given is that, and you see this in the deputy's response, which is included in our, we included her response in our report. Financial benefits are not considered a reason to be brought into a remaining care. And I think it's really important to focus on what's important here is that for a 54.01 order, one of the elements that needs to be obtained by the applicant, by the ministry, is the consent of the youth, as well as the consent of the proposed person to whom custody is being transferred. And so it's fine for the ministry to say that about their rationale and their belief about why people should not be brought into care, and we certainly take no argument with the notion that the purpose of kids being brought into care is not for the purpose of obtaining financial benefits. But what's important here is that they're obtaining consent, and in order to obtain that consent are providing information and have to provide accurate information so that that consent is valid. And that consent can be relied on by others who need to determine what to do in a particular case. So I think that while one can look at this at a macro level, what really is important is to focus on is what happened in this particular case. And we want to, and we'd also like to know how many other people this happened to as well. So with that, I think that's kind of an overview of our report. And I think with that, I'll turn it back to Sarah.
Thank you very much, Jay. Just a reminder for everybody, if you have any questions, please put them in the Q&A and we'll respond to them as quickly as we can. One question that has come up and we received when we released our report is the question of how much money would Alexandra have been eligible for if she had actually received those supports? So just on an order of magnitude, Nathan, maybe you could answer that one.
this is a question, it's an important question. We asked it to ourselves as well as part of the investigation. And essentially, we're not able to provide an exact dollar figure that would reflect the amount of entitlement that Alexandra could have gotten had she not been misinformed by the ministry about the effect of the 5401 order. I think what's key is that funding decisions of the type that Alexandra anticipated could be made on her behalf really vary and go on a case-by-case basis. They depend on a number of things that the former youth care themselves do, including the extent to which they need, say, healthcare or other supports. But certainly the post-secondary education values vary depending on a number of variables. So I think because of the disparity that can exist between the types of benefits that are available, it was not really possible for us to determine with exactitude what she might have been entitled to. But it's our view that this is based on the policy instruments available to the ministry and how those calculations can be done, that it was appropriate nevertheless to ask for a compensation and for the ministry itself to do those calculations as part of our recommendation, compensate her for what she could have gotten but for being misinformed.
Thank you, Nathan. Jay, we just have a question here from somebody who's wondering that now that the report is public, what are our next steps at the office to try to get these recommendations actually implemented?
Well, thanks for that. That's a great question, and something that we take very seriously because it's not common with our reports that that recommendations are not accepted by public authorities. Most public authorities do, in fact, accept the recommendations that we make. So one of the things that the role of the ombudsperson has been described when a recommendation is not accepted is to publish a report, and that's what we've done here.
Yeah,
but also to what the courts have described the role as being to marshal public opinion, so, an event like today's webinar, I'm hoping that people will learn more about the report, and going forward, we'll be able to, add their voice if they so choose to calls for change. With respect to the recommendations that have been implemented, we do monitor ministries and public authorities' promises to implement a recommendation. So the two that I'm very pleased that were accepted, and hopefully those two will reduce the likelihood of events that happened to Alexandra happening to other young people in the future, that we'll be monitoring to make sure that that the ministry does implement those. We don't just, when we do monitor, we actually come to our own independent assessment as to whether or not the public authority has lived up to the letter and spirit of our recommendations. So we receive information from them, but then we provide our own analysis. Often public bodies will say, yes, we're done. And then we'll have to, make sure that we agree with that. And then that'll be the subject of an update or monitoring report that we'll release in the years to come. But with respect to the three that the ministry has not seen fit to implement, I'm certainly hoping that others will also look at the situation, and if they think that it's an important principle at stake, that they'll add their voices to ours as well.
Thanks, Jay. Another question we've had is in regard to the policy of kinship care and keeping people with their families in terms of policy direction by government. I mean, the question is, isn't that seen as a good thing in this case? Nathan, maybe you could answer that question. Or Jay, if you're...
I'm happy to. I mean, we were very conscious in this report not to seek to undermine any notion of that supporting kinship care is a good thing. And in fact, as Nathan mentioned, Alexandra was already living with her aunt before the order was made. And in fact, it was never our intention in this report to sort of say this should have happened or that should have happened with respect to Alexandra's care. What our real focus is in a system that relies on a young person and the proposed adult with custody, or the person who would have custody if the order went through, is they have to get their consent. And that consent has to be based on providing factual, correct information, because otherwise the whole scheme is built on a faulty foundation. And so that's really the focus. We were, obviously the path forward for each child or youth who's in care is going to be different and governed by best interests. And kinship care is definitely one of those possibilities.
Thanks, Jay, and thanks to everybody here. Some great questions and lots of them coming in. We have a question, Nathan, about the fact that the report mentions social workers numerous times and a concern about the reputation of social workers in relation to this report. Wondering if this social worker was registered, and if you can tell us a little bit more about that.
Sarah. As a starting point, I think it's important to emphasize that the focus of the investigation and the report really is a story about Alexandra. And what we wanted to do was to amplify the experience that she described to us and the unfairness that she felt, and the unfairness that we ultimately found through our investigation in light of what happened as between her and the ministry. And so in that spirit and in that context, we of course are examining the action that the ministry took as part of its permanency planning process, which we've discussed at length so far. But this is not an exercise intended to lay blame at the feet of any one individual in the context of a complex permanency planning exercise that the ministry engaged in. What we see from the facts, as we've discussed, is that the permanency planning that occurred in Alexandra's case involved different aspects of the ministry with different types of information that needed to be corralled in order to give Alexandra and her aunt the information necessary to be able to give informed consent. So the issue, I think, is not to lay the responsibility or the blame at the feet of any individual person, but to speak of the ministry as a whole and the system that needed to be followed in order to make sure that Alexandra and her aunt got the information that they needed. So regarding the concern about the social worker, in BC, being a registered member of the college is not required, but these are functions done by the ministry. And so I think it's important to focus on that process piece rather than try to single any individual out, because that's not particularly helpful given the complexity of the way these planning processes unfold in light of the problems that we find here. I just don't think that would be appropriate to lay it at any individual's feet as such. It's the ministry that is ultimately responsible for ensuring that the best interests of Alexandra were protected, which is what we found did not happen in this.
Thank you, Nathan. And if there's any follow-up questions related to that, just please put them in the Q&A and I can get back to you on those. In terms of other questions, Jay, there's somebody who wants to know a little bit more about the recommendations that government actually agreed to.
Yeah, so obviously at the core of the problem that arose for Alexandra was really where the order was being contemplated and information was being provided to her and her aunt. And so there were, we saw and we show in the report, there was misinformation. There were also some procedural issues that related to pursuing information within the ministry, and then it not that loop not getting closed. So we thought that it was really important, and it's I think a reasonable expectation that ministry staff have a good understanding of ministry programs and eligibility for ministry programs. So that's obviously a staff training question, and the consequences, because there are consequences. And use in our report, we talk about, you know, if a young person has this permanency option, they're eligible for these programs. If they have that if they pursue that permanency option, there are different programs that apply. And so having a good understanding of which applies, given the various paths that somebody might be on, is, you know, certainly important. So so we thought that just that element of understanding was important, but also, as our investigation revealed, the ministry employee then pursued further information with a practice specialist in the ministry, but then the trail ran cold, and information wasn't provided back to that person to then relay back to the aunt. So so really there's procedural questions as well, but certainly at the core of it, staff training is important. The second one was and the second problem arose by the failure to provide a referral for independent legal advice. And that's required anytime the ministry is proposing a permanency plan for somebody who's over the age of 12, is for them to obtain ILA provided by the ministry. So, paid for by the ministry, but provided through an arrangement with the Legal Services Society. So that didn't happen, and we thought that protection, it was important that protection to have taken place, because that protection might have, had that happened, that might have actually been you know, enough redundancy in terms of safety systems in the ministry that the first problem would have been caught. But it didn't happen, and so we'll never know. But there are recommendations in those areas the ministry has accepted, and as I said, we'll be monitoring their implementation.
And Jay, just while we have you, we have a couple of questions regarding policy recommendations. Did we make any recommendations regarding policy related to these types of benefits and the permanency options that people have?
We did not. We focused on, we tried to focus very much on what occurred with Alexandra, and I will say that the ministry focused very much on their overall programs and their responses. And if you look at our report, you can see the response by government, because we reproduce the response we received from the deputy minister as an appendix to our report. And they focus very much on the broader government programs, whereas we tried to focus on what actually took place with respect to this particular youth. So it was, for us, it was less about you know, whether the policies were appropriate, but more whether the practices were.
Hey, thank you. And just looking at the time, we have about 10 minutes left, but I know people have other things they need to get back to. I don't see any more questions. Just one last kind of overall question, maybe Nathan and Jay, you'd both like to weigh in on, is, you know, what we would like organizations who are on the call or individuals to do. Jay, you touched on this a little bit earlier, but what are you hoping the takeaway is after this session today?
Well, whenever we release a report, I think we always want to make, you know, the widest dissemination possible. We hope, and for all our reports, that they provide good lessons for public administrators, even public administrators that are not the public, or that are not the public authority that's the subject of our investigation. And many of our reports are geared to that. But in a report such as this, where significant material recommendations that we've made unfortunately haven't been accepted, then what the Ombudsperson Act really calls on me to do is to report that matter publicly, and then it's for the public to consider in their own organizations as to whether these particular matters are things that they want to pursue in other fora. And we certainly recognize and respect that organizations may choose to do so, and that's really that marshaling public opinion role that the courts have set out for us. We'll always be here, and if other young people have problems, or other young adults have problems that are similar to Alexandra's, and you become aware of those problems, we certainly would encourage you to consider whether you may want to refer them to us, and we can look into their cases as well.
Thank you, Jay, and thanks to Nathan, and many thanks again to everybody who participated in the session today. Again, if you have questions for us, please just email us at the email shown on your screen, and we'd be happy to get back to you. If you'd like hard copies of the report, we'd also be happy to send you those as well. This webinar was recorded. It will be available on our website. And again, thanks to everyone.